Hello, folks. Welcome to the Wednesday weekly Cheltenham webinars. And I want to tell you, I'm really excited today because yesterday I had this amazing opportunity to celebrate Diwali at the Capitol. And in attendance was the Surgeon General, Vivek Murthy, the highest ranking Indian in office, Neera Tanden, including a number of congressional representatives, Pramila Jayapal, Ro Khanna, Raja Krishnamurthy, James Clyburn, which I was so honored to meet, Judy Chu, the ranking Asian caucus member, and a number of other renowned congressional representatives. So it was great to be there and hopefully represent some of your needs with the folks that have a voice. So I will continue to do that for you. But today, we are going to talk about a couple of other things. You have to excuse the venue. I am actually traveling to see my daughter who's in law school in St. Louis, and I'm in the airport right now. So doing my best to make sure that I don't miss the opportunity to connect with you and to talk to you about the latest things that are happening. So there's going to be a new prevailing wage form. What does that mean? It is always skeptical to me whenever a government agency changes their form. They don't do that without a reason. So the form will ask that employers list not only the primary requirements, but also the alternative requirements. And the prevailing wage office will now issue 2 prevailing wage designations for that. And you have to choose the higher. So most likely this is going to result in a higher prevailing wage designation. And that means that you have to be even more careful how you craft your PERM application, because remember, ability to pay is an issue at the I-140 stage. So you don't want your wage to be too much higher than what your current wage is, so you don't have ability to pay issues. So that makes it really critical that, you know, your attorney really focuses on crafting those job duties very carefully. And for example, they said that, you know, a software developer can either do a master's degree plus 3 years as a primary requirement, or a bachelor's degree and 5 years of experience as alternative. Previously signed on the primary requirement, which would yield prevailing wage level 3, now the National Prevailing Wage Center would assign 1 prevailing wage point for a master's degree plus, and another for master's degree plus 3, and another for bachelor's degree plus 5. So one could be, you know, a level 3, one could be a level 4, which would be the highest level. And of course, you have to choose the higher level. So that's why would be a shift for the software developer from $149,200 a year to $162,510. So that's why crafting that job description with the idea in mind that you have to meet the prevailing wage requirements in stage 2 is really important. And what I've seen most of the time is attorneys focus on whatever they're doing right then. They just focus on the PERM part without thinking about wanting to ensure that this gets translated to a successful permanent residence application all the way through. So if they don't do it, you got to make sure you make them do it. Secondly, they have removed the quotas on immigration judges. Before, there was a certain amount of cases immigration judges would have to go through. And you know what that happens whenever you have a quota is you sacrifice volume for quality. So this would at least put some integrity back into the judicial system. And they were talking about a plan to provide a kind of protective status for those who are already here, and a registry so that the individuals who are here undocumented, even though they're not in a status, could be here in a stay where they weren't fearing deportation. And as I talked to members of Congress yesterday, they are still considering how they can, accommodate the issue of, the backlogs. And this is what I had explained to them. For family-based, it's 480,000 allotable per year. For employment-based, it's 140,000 that are allotable per year. Of the 480,000, those who are immediate relatives, spouses, sons and daughters under the age of 21, parents of a US citizen, are not subject to that 480,000. So they get that 480,000, and then they subtract the immediate relatives. Now, for years, if immediate relative filings have been very high, more than 250,000. So you think the balance of all of that was left over, so you've got the 250, the 480, that would be allotted to the employment base. No, because Congress put in this quirky idea that it could be no less than 226,000, which makes no sense. So my point was twofold. Number one, what is that abstract 226,000? Where did that come from? And number two, that the Ming amendment doesn't make much sense because we're not seeing, even pre-COVID, any family-based cases that are going unused. But we see on the other side this 12-year wait. And what happens when these folks are waiting in the 12-year? And a lot of people didn't know this, that if they change jobs before they file the adjustment, they have to start the process all over again. That if they file for their children and their children happen to be over 10, 11 years when they file, there's a great chance that those children will age out before they're allowed to adjust. And they have to go through this, if you start from a F1, 20-year process all over again. So that's a family separation issue that never gets discussed. But I am making sure that your voice is being heard so that some point, if we're loud enough and we're consistent enough with our messaging, that can effectuate change. So now I'm here to answer any questions people may have. Please put your questions in the Q&A and not the chat, and then we'll get started with the questioning.
Hey, good afternoon, everybody. Can you listen to me? I get a thumbs up on the chat somewhere, or I'm also in the airport and talking very softly because there are two other people who are also using the meeting room. So I just want to make sure you guys hear. Eric, can you hear us? Please hear me talking softly.
Yeah, there's a little.
Yes. All right. Thank you. All right. Just to be courteous to the two folks who are also on a phone call. The first question here is, can you continue using H-1B for work purposes if you enter on advanced parole, or do you have to file H-1 extension after entering on AP?
No, I mean, as long as the key is you can enter on advanced parole, you can enter on your H-1B visa, as long as you don't work on your EAD for an employer who is not your H-1B employer. The minute you work for an employer that's not your H-1B employer, your H-1B is no longer valid. So it doesn't matter how you enter, doesn't matter whether you use your EAD or H-1B, you just don't want to work for an employer other than with your EAD, your H-1B employer.
All right, you got to pardon me, just to avoid any feedback. I'm muting myself after I, read the question. So take me, a second to come back. Second question: do you think it is worth staying in EB3 line for PD May 2012, or move to EB2?
I say this all the time. If I were going through a green card permanent residence process, I want to hedge my bets. I want to make sure that I'm using every means possible to secure my outcome. And quite frankly, we don't know how these, it all depends on how many filings are being filed and how many of those are being adjudicated by the USCIS that dictates the backlog. So you want to make sure that you hedge your bets. So why wouldn't you file? It's going to cost you a little bit of money, but in the long run, you know, it gives you more possibilities.
All right, next question from Abir Singhal. Abir, hi. Hi, Lakshmi. For our EB1C application, since the processing time for I-140 in Texas went up significantly, can we request to transfer to Nebraska, which is 12 months only? Or is that even more lengthy a process? Are there any initiatives to improve processing times for I-140 EB1C?
Well, not all I-140s are the same. One thing we can do, Abir, is we can try appealing to a local congressman or representative and, you know, kind of really highlight what you're doing to the community and how these excessive backlogs really impede your ability to, you know, do more with your investment into the United States. And I think that's something they should really appreciate. So, you know, I'm going to be out of the office because I'm going to visit my daughter for the rest of this week. But email me and copy John and Kara, and we can get started. I'll make sure when I get back on Tuesday that we get in touch with one of the congressional offices or one of the senator's office to see if we can do something about that.
All right, folks, just want to remind you about putting your questions in the Q&A and not the chat, and use the chat for responding. But I'll just take this question from the chat. Raj D is asking, when do you think EB3 2013 December will be current?
You're asking a question. If I knew the answer, then I would be able to predict the lottery. I would be able to go to Vegas and make tons of money and help all of you with an EB5 investor visa application. Unfortunately, there's so many factors that go into the movement that even the person that is heading it, Charlie Oppenheim, has had it wrong, because you know he can anticipate what they're going to be, but it's all speculation. So we can only guess.
All right, next one is EB2 to EB3 downgrade is filed in amendment mode, got RFE on ability to pay for the downgraded I-140 application. If this EB3 140 is denied, then can I withdraw I-140 application so I can retain the original EB2 I-140?
If you would like, we could review your I-140 ability to pay. I mean, you want to, you know, if you withdraw it, if you filed an adjustment of status along with it, then your adjustment of status will be lost. You should never file an amendment. You should always file a new petition. I don't know why your attorney filed an amendment. It makes no sense to me. And they should have assessed ability to pay before they filed. That's what good attorneys do. You review ability to pay before you file the I-140 so you don't get an RFE. And there are ways in which you can prove ability to pay besides just the net income on the federal tax ID. It's the wages you're being paid. You can use a combination. There's a net current income based on the balance sheet on the tax returns. So you would want this to be approved if you've got an adjustment attached to it. And then you want to file a new I-140 EB2. I mean, I'm sorry that whoever guided you incorrectly. But those are the things I would suggest.
Now, if you want to discuss more after your attorney responses to any of the questions, then just send an email to info@shallowlaw.com. I'd be glad to talk to you guys in detail. Next question is filing 485 without joining the employer who hold my I-140 cause RFE? Question mark.
Oh, will it cause an
Yeah.
RFE? Okay, number one, when you file an I-140, both you and your employer should have, at that time you filed, the present intent at that time for you to work with the employer. If you change your mind later on, it's okay, because remember, you're still eligible for AC-21. So once the I-140 is approved and 45 is pending 180 days, you can change your mind to pursue your permanent residence with a different employer and having them file an I-45J. Now, what I think may happen at some point, it hasn't happened yet, it's just my prediction, that because they're seeing a number of these downgrades with folks that are filing for employers that they're not currently working with, they may at some point say, prove to me that you have the present intent. So I've been advising everyone for about a year now, make sure you document if you were filing with an employer that you're not currently working with, that you have the present intent to work with them. Like, for example, an email saying, hey, once the green card is approved, because remember, you don't have to do it now. It's only once the green card. Once the green card's approved, I'll start working with you. When should I start? How should we transition? Is there a memorandum of understanding between us? Is there some kind of communication? Most of it's oral. That doesn't do anyone any good. Oral testimony is parole evidence, and it's hearsay, and it would be your word against, so you want something more concrete than that. But it won't in and of itself result in an RFE. I-140 is approved, 45 has been pending 180 days, and you're working the same and similar. But for all the rest of you, I am telling you that you may want to watch out for that issue popping up at some point.
All right, next question is from the Telegram group. If we interfile back to EB2, what happens to EAD cards? Those are issued under EB3 petition I-765.
Nothing. You can still work on your EAD cards. You're just telling the USCIS, because you're permitted to do that, that I've got two petitions. So approve it under either.
All right, the two people have gone, so I can speak a little louder, but not very loud, but just wanted to let you know. A bright Wednesday afternoon here overlooking the Potomac River, beautiful weather. So next question, I filed the FOIA and got the documents that my attorney filed for EB2 to EB3 downgrade. How do I know if the I-140 is filed as an amendment or as a new?
You can look, it's how they complete. If you read the I-140, it will, I'm trying to remember what number question it is, but it'll ask, is this an amendment or is this a new petition? They should have checked new. And then there's a question that says, do you have the original PERM, or are you requesting the USCIS to request the PERM? So if those two boxes are checked, then it's a new. If they checked amendment, then they filed for an amendment.
Next question, do you expect retrogression in 2023 for EB2, EB3?
Shaker, you still may want to put your thing on mute when I'm speaking, so there's no, okay. I think there is going to be, in 2022, you're going to see it probably for at least the first portion of 2022. And then it depends on how many applications are being filed. Hopefully this will all kind of, because less people will be, as you have more backlogs, less people will be filing. There are hopefully the budget, the two spending bills will pass, and there's additional money that's going into the USCIS, I think 300 million more than last year. So processing will increase. So I think it's going to kind of peter out by 2023. But I think in the next couple of months is going to be a little rough.
All right, next question. Manish Agarwal, I'm not sure if I picked this up, but would a new I-140, I-485 for EB2 better or interfiling the I-485 filed for EB3 if I'm now retrogress from November, but current using date of filing?
Right. If you've got, here's the strategy. You have to look at it two ways. If you already have, I'm echoing. If you already have an EB3 filed with an adjustment of status, then interfile. That makes sense. Don't have to file a new. Let's say you didn't downgrade by filing a new petition, but you amended it. And now you're in a situation where you don't have a valid EB2. In that case, file an EB2 with the new adjustment of status. Because you can't interfile until A, the first previous one is approved. And then secondly, you can't interfile if you don't have the EB2. So a lot of people, there's some folks that didn't choose to file an EB2 and EB3 when they could have. There's some people that downgraded through an amendment. So for those individuals, filing a new adjustment would make sense. For everyone else, interfiling makes sense.
All right, next question. Can I put the attorney? Sorry, next question. Can I put the attorney fees in tax returns since it was deducted post-tax for my green card, PERM, and I-140?
Well, first of all, you're not supposed to pay for your PERM by law. It's prohibited. Your employer is supposed to pay for the PERM by law. So number one, I'd get that rectified. Number two, the other expenses, you can pay for. They deducted it from your payroll, which is something they can't do. That's an impermissible deduction. They could ask you to pay for it, but they can't deduct it from your payroll. So there's problems all over that.
All right. I think those are the questions right now. We are waiting. I just wanted to, first of all, I think the shoot up questions. All right. What I was trying to say is, we've got, looks like the entire team of Chella Law on the webinar. I'm excited to see all the team members. So let us know to the team members how we are doing on the webinar. You're going to send us your critique. Glad to see all of you out there. All right, next question is from RB. Can we interfile to EB2 only when the final action date is current or ACN? We do it before, or can we do it before? Okay, let me read it again. Can we interfile to EB2 only when the final action date is current, or can we do it before?
You can do it before. And you just have to wait till it's better to wait till the I-140 with the underlying adjustment is approved before you do that. So once it's approved, your previous I-140 that you filed last year, then you can go ahead and interfile.
And next question. The downgrade application is denied due to some employers' pay issues, and 140 downgrade is filed in amendment. So can I change my employer now So can retain original EB2 I-140 date. Anywhere to retain original EB2 I-140.
Right. So the priority date, but you have to have an approved. So do you have, if you filed a downgrade as an amendment, technically your previous I-140 is no longer valid, but I think a priority date attaches with you, even if it's subsequently denied. No, it has to be approved before the priority date is attached to you. So you did have an approved I-140, so effectively that priority date is attached. And even if the downgrade is denied, as long as it wasn't denied because of fraud or misrepresentation, I think it sticks with you. But email us at info@cellolaw.com so I can double check. I am pretty sure. I think we had a webinar on this October or November of last year, just on priority dates. So I think Kara will put the link in, the chat so that you can take a look at that. I think we went over instances where the priority date, when it attaches, and instances when it doesn't. So off the top of my head, I remember all of it. There's a piece I'm not remembering. So email us or look at that webinar, and that should help you in your process. And what I want to take this time to do is say, hey, I want to do a shout out to all those people on YouTube. How are you? Thank you for joining. For those of you who are new to our weekly webinars, you can see how I try to be committed. I'm sitting in an airport. I arrived here at least 3 hours or 4 hours earlier than my flight, just so I could be set up and ready for our webinar today. And we're going to have a lot of great content. So thank you if you're joining for the first time. For all of you who have been joining every week, my appreciation is tenfold. And next week, we're going to talk about, because we've gotten a lot of questions about the EB5 program, debunking some of the misconceptions with regard to processing times and processes. And we'll see if Mr. Daniel Robinson is free. Maybe we can coax him to join us as a guest. And with 3 or 4 EB5 projects under his belt, he can talk about what are some of the things that he does to ensure a successful outcome in terms of financial structures for his projects. Because he's been doing it so long that he has had to ride through many a turbulent economic process. So we'll see if he can join us and talk a little bit about best practices. The other thing is, if you all have not joined us on our various outlets, we try to communicate our message in different ways. And I promise, Kara, I'm going to start tweeting with my own e-handle. I'm going to start using all the pictures I got last night with Neera Tundon and Pramila Jairam and Rokamna and all those great people. And I will start doing it. It's a second language for me, so I do the best I can, but I will. And so we use Twitter to communicate those really quick bits of information that we want to get out. Facebook, you get a more detailed explanation. We have our YouTube, which is rich with content. And so many people have told me that we explain things in a very, in a way in which they haven't heard it explained before. So you can learn about your process and be, steer your ship, because you're the captain of that immigration ship, but you need to have some navigation to help you. And so we provide that navigation. So that's what YouTube does. If you subscribe, you will get a notification every time we upload something. Then we've got our Telegram group. It is a group that I am very fond of because it's a community. That's what we've tried to build. We've tried to build a community of people who are going through the same thing, who can help one another. And as a legal resource, we want to be there to make sure that there's no misinformation that's disseminated, that we can help steer that. And the reason why we created it is I got kicked off of several forums because they wanted to make money off the community. What kind of community do you have that you're trying to commercialize it? If we can answer your question we will send you the information. I have sent information to people who needed to send information to their attorney. I didn't say to them, hey, only if you use me and leave that attorney. Well, I sent them, I told her, this is what you need to tell your attorney. Here's the new regulations. And this individual did not have to leave the country as a result. So that was what I was so excited about. And we can't do this on our own. I have got an amazing team. Shaker and I are the face, but we would not be able to do it without the rest of the team and their just phenomenal effort. And a special shout out to Kara Wood, who most of you know, much better than you know me, I would think, because she talks to all of you so much all the time. So Kara gets a special shout out. And please, if you've got friends that are in this predicament, we're going through this, share our webinar details. As you can see, I'm really committed to make sure we get the message to you and share our social media resources with them too. That's the one thing we are here to serve you. That's the one thing you can do for me, is make sure that our voice gets heard in many venues.
All right, sounds good. We got quite a few questions come up. First thing, just to remind you guys to look on the chat about the Downgrade webinar from last year. There's a link, and all the other social media links are posted there. Next question, can you maintain your H-1B for work purposes after entering on AP?
Yes. And we have a webinar on that that talks about the difference between AP, EAD, H-1B visa. I said it earlier today, but you can see the detail on the webinar that will be linked. It's not the mode of entry, it's whether you continue working for your employer. If you work for an employer other than your H-1B, you've violated your H-1B status. Everything else doesn't matter. That's the crux of it. But take a look at the webinar so you can hear in detail the permissible and impermissible uses of those tools.
Next question, if no spillover based on 7% for EB3, till what date retrogress will happen?
It all depends on how many people are then going to switch back to EB2, or they're going to leverage the EB2 mechanism. How many new filings you're going to have? There's a lot of calculations that go into that, and that's what will dictate how much EB3 will retrogress. I suspect it will continue retrogressing at least till early 2022, and then maybe it will subsequently start to even out.
All right, next question. What happens to the timely filed pending H4 and H4 extension if I have used my AOS EAD as a derivative applicant?
It doesn't, if you're a derivative, it doesn't matter. The only restriction is for the primary H-1B candidate. If you're a derivative, you can use your H-4 EAD, you can use your AOS EAD, you can work for anyone you want, you can flip burgers at McDonald's, you can do anything. It doesn't matter. So it is only the primary visa holder that has the restrictions with his employment-based non-immigrant visa. The derivatives do not.
Next question from Harish Barsiwal. My wife has a job offer. Can she use GCEAD? My I-140 downgrade still not approved. Any risk on my status changing to GCEAD, or I'm still on H-1B?
Okay. Harish, welcome, and thank you for your question. It's a good question, because here is what I would tell you. Your adjustment is still pending, but you were issued AP and EAD pursuant to that adjustment. Your invalid H-1B status, and I'm going to assume that you're maintaining that H-1B status, which means you have not worked for anyone other than your H-1B employer, whether it was through an EAD or your H-1B approval notice. Now, your derivative, as I stated earlier, can do anything they want. Their status is always dependent on their H-4 status, if they're on an H-4 as a derivative, is dependent on your maintaining your H-1B status as the primary. So they've got a tremendous amount of flexibility. But you need to ensure that you're maintaining your H-1B status. So I tell people that even if they're going to port employers pursuant to AC-21 and they're eligible with all the three conditions, that's fine. But consider transferring your H-1B as well, because that's your safety net. As long as you have an H-1B, no matter what happens, God forbid, to your adjustment of status, you're always in valid status in the US.
All right, just want to draw your attention to the chat where the team had posted the AP travel related webinar. So check out those links.
And you know, this is such a common question. Share it with your friends, because I hear this almost, I hear this almost all the time, at least 2 or 3 times every webinar. So if you've got friends that have filed and are wondering, share the link with them and help them out so that they understand the nuances between AP, H-1B visa, EAD, and working on your H-1B, and how does that impact with the derivatives?
You know, people from southern India, especially Andhra Pradesh, will relate to this request of mine. You like us, you share with 3 people about us, you tell them about us. Let those 3 people tell 3 other people about us. It's a dialogue from a Chiranjeevi movie. Just want to request that, get excited. What's the next question? This person says, happy journey and thanks for taking care of call from the airport. And his question, his or her, EB2, EB3, I-140 downgrade is approved. How interfiling to EB2 helps now? Question mark, priority date, February 2014.
Well, remember the approval of the I-140, that's not the reason for the interfile. The reason for the interfile is the priority date, right? You've got EB3 that was advancing before, you've got EB3 now that's retrogressing, and you've got EB2 that's pushing forward. The strategy behind interfiling is you're just telling USCIS, hey, I've got an EB2 and EB3. So please don't, you're giving them 2 mechanisms in which they can approve your adjustment, right? It's not that you're saying, you're saying I've got 2. So if EB2 advances, approve EB2. If EB3 advances, approve EB3. You're saying I've got 2 ways to do it, and you can do that. Why wouldn't you want to do that? Why would you want to just give them 1 when you have 2?
All right, Sagar Kulkarni and Abir, appreciate your comments and thanks for your appreciation. Next question, interfiling to be done by any attorney or by my company's attorney only? Can your law firm help filing in case?
Yes, we can interfiling, because that's more about the adjustment of status, as I said, An adjustment is statement-based process. It's a personal process. So we can assist.
Harish, thank you for your comment. Next question.
Now it's better.
Can you hear me now? I have EAD and AP. What happens if I change my current employer by EB3 downgrade and move to another company on EAD, and I file for my H1 extension later?
So let's pick up all the pieces. You're currently working for your employer that filed your downgrade, and I would assume as a new petition or as an amended, and you want to know if you can change employers now. That means your I-140 has to be approved, your 45 has to be pending for 180 days, and you're working for same or similar employment. Then you can change employers pursuant to AC 21, have the new employer file an I-45J, and that employer can also file a transfer to transfer and extend your H-1B.
I just got Rai, the follow-up question: how to file for my H1 extension once the I-94 expires?
Okay. If you have had a valid H-1B in the past 6 years, then you can file a new petition on the basis of the fact that you're not subject to the cap. Now, here's the tricky part. You did file an adjustment. Remember, you can get, if you've maxed out on your 6 years, you get 3-year renewals pursuant to the fact that you've got an approved I-140, but there's no, your priority date is not current. Now, what we've been doing is we've been doing 2 things. Even if the priority date is current, but it's been pending for a long time, we cite to the fact that these ridiculous processing times and the ever pending idea of retrogression should allow this individual to extend, number 1. Number 2, if your priority date, if you filed and now your priority date is retrogressed, then you meet the requirement. So they would file a new, but not subject to the cap, and you would cite to the fact either of the delayed long processing times or the fact that the numbers retrogressed and your application is no longer current. Are we getting any questions from YouTube? Hey, YouTube guys.
I don't see any yet, but be glad to take any from anywhere. Next question. I wanted to ask, how long does it take to get my husband's green card through asylum via Texas visa office, filed in February 2019?
Yeah, those cases take a long time. Asylum cases take an exceedingly long time. So, you know, and especially now with no minimum case requirement, the immigration courts being inundated, it could take a long while. But if you're a US citizen, you could sponsor them even if they've got an asylum application pending. And that may be faster than, and I don't know whether you're, because you said, my husband, how can I bring him on asylum? Maybe what it is you filed asylum and you're trying to bring him in as a derivative. And there's a separate process for that. But the overall process for asylum takes a very long time.
You can send us an email, you know, with more details so we can answer. Next question. Now, will they process I-485 based on receipt date or priority date after retrogress?
Remember, if your case is retrogressed, that means they will hold it in abeyance. That means they'll say, okay, we're going to wait for this number to become current and we're going to put it aside. We're not going to work on it anymore. So if it's retrogress, they're not going to be processing it, which goes back to the fact, why would you want to have an EB2 and EB3 with them? So as these numbers, we've seen them kind of teeter back and forth, you've got your two options in front of the USCIS, and you're not waiting.
All right. The person asking, the woman about asylum, I think she commented, it says, his asylum is approved, just waiting on the green card. I'm not a US citizen.
Oh, okay. Then if his asylum has been approved, again, it still takes, and I'm trying to remember the current processing time, which is never valid, but email us and I'll check in on that and I'll tell you, even after it's approved, for some reason for that process, it takes an exceedingly long time. But I will tell you what the latest news out of Texas is. Email us at info@chellalog.com.
All right, next question from Chad Ashok Jagalamuri. I have I-140 with company A. After 1 year, company B is acquired company A. Do we have to file I-140 amendment?
Yes. Absolutely. You file it as a successor in interest. It's a pretty straightforward program. And, you know, there may be some strategic ways to leverage this as you're filing it. You may want to file two, or you file one and file another for as you're doing this. But the short answer is yes, they must.
All right, next question. Can you do a side hustle? Can you do a side hustle on GCEAD while working on H-1B for your sponsoring employer? I'm sorry, I'm just
The side hustle thing.
Hustle.
Well, you know, as the term hustle kind of denotes, hustle is never the mere fact that you use the term hustle instead of gig leads me to believe that you probably know the answer to that. You can do it, you just you'll no longer be in valid H-1B status. That's it.
All right, on the chat, the team has posted saying USCIS states that the Texas Service Center has an estimated processing time of 14.5 to 43.5 months for I-485s based on a grant of asylum more than 1 year ago. So that's your update on that. Well, while we are ready for some more questions, I just want to, piggyback on what your attorney said about the EB5. We've been telling you about this pending appeal from the government, USCIS, on the reversal of the judge in California in June, which made the current investment level at $500,000 for a project anywhere in TEA, or $1 million for a project anywhere in a metro area. So what we are trying to tell you, anybody out there who's got the resources, who wants to do the EB5, this is the best time to do it. While the verdict is not yet out yet. So till that appeal verdict is out, any applications that are filed now will be honored at the, $500K for a TEA or a $1 million for a metro area. So it's a great opportunity. So if you need more information, you want to discuss specifics, send us an email at info@chellalog.com. But don't lose the opportunity. You have the resources, you want to do it, let's do it.
Yeah, and next week, I will discuss how I think the processing times are going to get shorter for EB5 applications, despite what you all see on the website, and why that website information is not totally accurate. They just kind of dump a lot of data in that, number one. Number two, I'm going to tell you a little bit about the USCIS policy manual that adjudicators have to, what do they review when they're reviewing a EB5 in investment? And what are some, like for example, if a project has already had a regional center designation, they've already reviewed those details. And so we found the provision was in the policy manual that says, hey, adjudicator, you don't have to review anything about the project again because it's already been certified by the USCIS. All you have to do is make sure that the source of funds are good. Giving you tips like this and other things that adjudicators will be looking at is what our topic will be next week.
Okay, we'll take these two more questions that are here so that we can, wind down and just get with
Yes,
So next one, how can I see my PERM status online?
I'm not sure whether you can do it. I know attorneys can do it. Kara may be able to show some insight. I don't think the individual can do it because the login is given to the employer and the attorney. And I think if, at least if we give you what the current processing time is, we file a lot of PERMs. So we have a pretty good idea of what PERM processing timeline is. That should give you some idea as to where yours is in the process. And I think Kara will update the information.
All right, last question. EB2 EB3 downgrade filed in amendment and EB3 I-140 got approved. And can I do interfiling now? Priority January 2012.
If you did an amendment, remember you no longer have your EB2. So you have to have an EB2 to interfile. If you filed a new petition for an EB3, then you have the benefit of both. If you filed an amendment, you had amended, that means you had changed your EB2 to an EB3. You don't have an EB2 anymore to interfile. You can either file a new EB2. It's going to take at least 6 months for you to be able to upgrade that to premium. It's got to get approved, and then you can interfile it.
All right, before your attorney closes, I would just want to talk about the World T20 Cricket that just started last week. It's been a while since I've talked about cricket. Well, I want everybody out there, whichever country you support, very good. For all the folks from India, please send some positive thoughts so that on the Sunday we can win a game against New Zealand. And I congratulate Scotland, Namibia, Sri Lanka, Bangladesh for making it to the Super 12. But hey guys, let's see the best team win.
And
but
Pakistan,
at least let's make New Zealand, let's have a good game on Sunday. That's all I want.
And I wanted to say that Pakistan played an excellent game.
Yeah, I've never seen Pakistan team play that excellent back to back. I'm not going to talk about the team against India, but they played very well. And they played very well the other day too against, what's the other team? I forgot. In New Zealand, yeah. So kudos, excellent opening partners, opening batsman, and that opening bowler, man. So definitely they're playing very well. But at least I like India to be in the semi-final. But may the best team, that's the idea.
Yes. Well, thank you again. We got to catch our flight, and we will see you next week when we talk about all issues of EB5 and still give you the updates. Thank you for joining, and I look forward to seeing you then. Take care.
Have a good week.
Thank you, Shaker.
Thank you, Lakshmi.